Our second case scheduled for oral argument this afternoon is Florida Highway Patrol versus Lashonta Renea Jackson. Again, we have reserved 15 minutes per side for the oral argument. Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
So noted. Madam Clerk, you may continue, counsel.
Thank you, Your Honor. Brett Thomas on behalf of the Attorney General's Office, and I have the pleasure, together with my co-counsel, of representing the appellant in this matter, Department of Highway Safety and Motor Vehicles, Florida Highway Patrol. The decisions of a governmental entity when exercising its discretionary power to enforce the law and to act to protect public safety, most notably when we're speaking about the actions of judges, prosecutors, and law enforcement, are protected by sovereign immunity.
Counsel, before we get into the substance of the issue here, I want to talk a little bit about this court's jurisdiction. So, we have a lot of case law that talks about how important it is to separate the duty analysis from the sovereign immunity analysis. And, that's a pretty helpful analytical framework, I think, for these cases. But for most of the cases until a couple of years ago, they were either up here on cert or they were post-judgment. So, you could kind of analyze them together, even though we've been told that they're separate. But now we have an interlocutory appeal that's available only for sovereign immunity, but this case seems to kind of talk about them both. Of course, your summary judgment motion had both issues in it. So the way I see it, I think there's kind of 3 ways that we can handle this. Number one is we can sort of presume that the duty is so closely related to the sovereign immunity analysis that we have to consider them together. The second is maybe ignore the duty analysis, even though it was briefed and even though it was part of your motion, and focus only on the sovereign immunity analysis. And the third, which I think is kind of implied by the Wallace and Pollock decisions of the Florida Supreme Court, is that we presume, for purposes of this case, that a duty does exist, and then move on to the sovereign immunity analysis based on the existence of that duty. So do you have an opinion on which one of those we should, how we should handle this case?
I would suggest that the two concepts are so closely related. The cases that we have cited in our briefing, in fact, speak to that issue. And as you have noted, there is a constant intertwining of the duty concept with the sovereign immunity concept. And we know from the Supreme Court that it says there must be a duty before you even reach the sovereign immunity.
Well, how do we deal with the fact that the rule specifically says sovereign immunity?
Good reasons that what I would suggest we do here is that you deal with both the concepts. First of all, the answer brief of the appellee is comprised in large part of the duty argument. And so it seems to me appellee has placed that argument in front of you and has invited the court to weigh in on the duty question. And as you've noted, the Trianon Park and Commercial Carrier, the Pollock cases, all of which are Supreme Court cases, constantly refer to the question of whether there is or isn't a duty, even when discussing the narrow issue of sovereign immunity. Okay,
but you would agree that this is a jurisdictional issue?
I would agree that the strict jurisdictional topic, what allows us to be here in front of you, is the sovereign immunity issue. And that's why in our initial brief, we did not address the duty issue at all. We confined our arguments only to the issue of sovereign immunity. But it's clear from the appellee's answer brief that, in my estimation, the majority of his argument relates to duty. So I would suggest.
Well, I'll ask them the same question. It's not really important to me what they're arguing. I'll let them justify what they're arguing. I want to know whether we have the jurisdictional ability to address the duty question, and if so, how?
That's a very good question, Your Honor. And in fact, we quizzed ourselves about that. Is it appropriate for the court to entertain the duty argument? I can tell you that
our court bases its decision solely on the duty versus no duty argument. Would that issue have been appealable before this court in this appeal?
The rule does, the non-final appeal rule, Your Honor, does not allow an appeal solely based on the denial of summary judgment and the rejection of our duty arguments. That is correct. But again, I would simply suggest that because those two concepts are so totally intertwined, and because the Supreme Court has itself said these are parallel questions, that is a quote, I believe, out of the commercial carrier or Trianon Park case.
Now,
These are
how
parallel.
does the commercial carrier and Trianon Park cases apply to the facts of this case?
The reason that those cases are important, Your Honor, is that they create, the Trianon Park especially, and not so much commercial carrier. We address commercial carrier only because that issue is raised, the four-prong test that can be used by courts that evolved from the Evangelical Brethren test. We only address that in response to Appellee's suggestion that test is persuasive in this case. We do not believe it is. The reason that we don't believe it is because in this particular case, and it bears some discussion of the facts, this case began at about midnight on January 28, 2012, when there were accidents that happened closing both lanes of Interstate 75, as well as both lanes of US 441. US 441 and I-75 are, of course, the major north-south thoroughfares that transport traffic to and from the southern and northern parts of the state. Those were shut down, and the FHP arrived on the scene and did, in fact, continue and authorize the closure of those roadways. At or around 3:26 a.m., and we know it to be about that precise because we have radio communications, and after having been on the scene, the incident commander, Lieutenant Gurley, determined that the visibility was sufficient so that he could restore the normal flow of traffic to Interstate 75.
Is that a planning level decision?
It is, in fact, a Category 2 decision. We think it is directly in the heart of a Category 2 decision, which is the enforcement of laws and protection of public safety. The deposition of Lieutenant Gurley, who was the commander there, he described what he was doing when he was making that decision to reopen the interstate. And he was concerned, and had to be concerned, not only with the traffic on the interstate, and of course we know this gentleman was involved in an accident at 4:01 a.m., some 35 minutes after normal traffic flow had been restored to the interstate. But what we know is that Lieutenant Gurley made the decision, and this is not disputed, even though we hear some indication that Appellee disputes it. But the consistent testimony was visibility was sufficient to restore the traffic flow to the interstate. And it was not until 35 minutes later that this accident happened. So at the time traffic was restored, the normal flow of traffic was restored. FHP had no connection with this gentleman, did not know of him, and had engaged in no operational act.
Gurley also testified that 4 FHP troopers were posted on I-75 at the time of the reopening of I-75.
That is true, Your Honor.
What effect does the placement of the troopers on I-75 at that time have on your operational versus planning level analysis?
I don't think it has anything to do with this case, Your Honor, and the reason that it doesn't is that if you consider an operational decision, and the Supreme Court has defined an operational decision as one that is not necessary to or inherent in policy or planning, but which reflects only a secondary decision as how to implement the decision. There's two important points about that. The decision to reopen the interstate was anything but a formulaic decision. It required the expertise, the knowledge, the experience of the FHP. The FHP is charged with doing these exact things. This is not something that's done by anyone else. More importantly, perhaps, is that the empowering statute under which FHP operates, 321.05, the general duties as enumerated in that statute are to patrol the state's highways, to enforce the law, to control the flow of traffic thereon for the purposes of protecting the public safety and the public property. This is exactly what they did, what the FHP did at 3:26 a.m. They were controlling the flow of traffic. They had had the interstate shut down, and now it was reopened. It had been restored to its previous condition, that is, no restrictions, normal flow of traffic. The Pollock case tells us that 321.05 does not encompass any specific duty owed to an individual. That is, it does not and cannot support tort litigation. And what we have here is a situation where they're acting in accordance with their powers and duties under 321.05. Lieutenant Gurley is exercising his discretion in order to open the interstate, and he does so not just for the traffic on Interstate 75, but as we pointed out in our briefing, he's concerned with all of the traffic, all of the motoring public. Again, the general duty he has to protect all of the motoring public. He's diverting traffic onto rural roadways. He's had the traffic stacked up on I-75 for hours. He's got the only other detour route that's usually used, US 441, is also closed. He has to think about all of the risks associated with the entire motoring public. And so, because when FHP reopens the interstate, it had had no contact with this gentleman. There is no way that there is any operational activity that is associated.
Well, I'm sorry to interrupt. Let me go back to what I said before, because I think it's going to be important. I don't want you only focusing your argument on duty. Let's say that we don't find that we have jurisdiction to discuss duty, which I think is what you've kind of focused your substantive argument on. Tell us how we can apply the Evangelical United Brethren
Well, first of all, Your Honor,
to determine whether they're sovereign.
Our
I want you to get to
argument
that before your time runs out.
our argument is that you don't even reach the evangelical.
Let's say we
Brethren
do.
test. If you do, the answer is still that it is a protected activity. First of all, the Supreme Court has told us that you only resort to the Evangelical Brethren test if there's no, or if there is the existence of a common law statutory duty. There is no common law statutory duty here, not any duty owed to this individual. The second reason is that even if you look to this four-pronged test, the only items that are at issue are items 2 and 3. It is our opinion that the answer to both of those questions remains in the affirmative and confirms what we know by looking at the Tryon and Park
Counsel, it's your
taxonomy.
position that this court can make its determination based solely on the Supreme Court's opinion in Tryon and Park, specifically categories 2 and 3 of Tryon and Park.
Your Honor, that's exactly our position, that you needn't look to the Evangelical Brethren test because, as Tryon and Park points out, and it does commend the use of the Evangelical Brethren test, but only when there's a reason to do so, only when the answer isn't clear. It's our position that the answer is crystal clear in this case. The statutory duties, the exact activity that the FHP was engaged in falls absolutely within the Category 2 discretionary power regarding the enforcement of laws and the protection of public safety. I would add that my opponent has argued that it's a Category 4 decision. However, Category 4, as is articulated in the Tryon and Park case, says that this involves providing professional, educational, and general services, and most of the time relates to things like doctors and teachers and other people who are employed by the government, and in activities that are typically or can typically also be filled by private citizens. This in no way fits a Category 4 decision. We know that law enforcement is not performed by private entities. It's always a government agency, and so therefore we believe that even if you look to the appellee's argument that this relates to Category 4, the answer has to be that it does not. It falls squarely within the Category 2 decision. Moreover, we know it's not operational. As we've argued in our briefs, we believe that this is an activity that required absolutely the discretion. It also invokes the basic policy of the FHP, because this isn't a matter of just, oh, well, you could have waited a couple of hours to open the interstate. It is the FHP who's charged with making these difficult decisions, and it involves all manner of policy, including manpower, the safety of its own personnel.
Would your analysis be any different had a corporal or a sergeant made the decision to close the state as opposed to a lieutenant or a captain?
I don't think it would have, Your Honor, because it would have involved whoever had the authority to make the decision. And in fact, in this case, there was a sergeant who was overseeing the operation until the lieutenant came from home. He was not on duty. He came onto the scene from home, and it was at that point he assumed control. So the sergeant would have had the authority had he been the one who made the decision. But the answer to the question about whether or not that decision would be entitled to immunity would remain the same. FHP would be entitled to immunity because that particular person, so long as there wasn't some odd, allegation of him having acted outside the course and scope of his employment, that the FHP would remain entitled to immunity even if it were made by a sergeant who was properly the incident commander.
It wasn't your rebuttal time.
And my rebuttal was going to be mostly as to the duty argument. So what I will do is stand on the arguments we've made in our briefs, and I thank you for entertaining.
Thank you, Counsel.
May it please the Court? I'm Jack Fine, along with Melissa Sheldon, representing the appellee estate of Montavia Robinson. And we disagree with every single position, and it's no surprise, but we disagree with every single position.
Well, let me start with the same thing I started with Mr. Thomas. So here's my concern is there's going to be a duty of care issue in every single negligence case.
Right.
And if a defendant moves for summary judgment and it's denied, well, you can move for a cert petition, but most likely you're just going to go to trial, and then you're going to appeal. The defendant's going to appeal if there's an adverse verdict. The reason it seems to me that the rule was amended was specifically because the trial court doesn't have jurisdiction to hear a case against an entity that has sovereign immunity. So I think that's why, you can correct me if I'm wrong, but I think that's why the Supreme Court amended the rule to specifically say that, well, we'll allow an interlocutory appeal if the issue is sovereign immunity. So given that kind of really narrow basis for this extension of interlocutory jurisdiction, why is it that we should consider duty, in as much as Mr. Thomas pointed out, the majority of your brief is devoted to that?
I think they are inextricably linked, and I'll talk about that in a minute. But I have a slightly different take on jurisdiction, and I don't pretend to have anywhere near the knowledge of anyone on this court about what the Supreme Court intended. But it seemed to me that when the interlocutory appeal was taken, it perhaps shouldn't have been, because the court didn't rule. When you look at the court's order, the court didn't rule that there's no sovereign immunity. In fact, appellants filed a motion regarding certain policy questions in this case and said to the court, we don't want these considered because there's immunity here for policy and planning. If you look at the criticisms levied by the FDLE report, there were issues of policy and planning. So the court never ruled.
Well, no,
say.
I mean, they moved for summary judgment. They moved
Yes.
for it, among other things, on the basis of sovereign immunity.
Yes.
The court essentially said denied.
Yes.
So how can you say that the court did not rule on sovereign immunity in as much as that was the motion they were ruling on?
Because the language of the rule says that is explicit.
So did they get a ruling on sovereign immunity at all?
No, the court didn't rule that there's absolutely no sovereign immunity as to everything in the case, and that's the language of the rule. But I want to get that. That's my interpretation, and you can do with it what you please, obviously. But that's my interpretation. That the rule says one thing. That's not what the court ruled, and perhaps this appeal shouldn't be here. But because the
That's
appeal,
the next
yes,
question, counsel. I'm looking at the judge's order.
Yes.
Trial judge's order, and it says disputed issues of material fact exists, including but not limited to the extent and adequacy of the department's continued monitoring of the roadway that prevent the entry of final summary judgment. Now, is it your position that the trial court did not rule on sovereign immunity?
the court ruled on that particular issue of sovereign immunity, but the rule of appellate procedure that says they can take an interlocutory appeal specifies that the court has to absolutely rule there's no sovereign immunity. And when they filed that motion in limine saying some of the issues in this case remain policy issues, and
the motion for summary judgment was based in part on sovereign immunity, right?
It was.
So the issue was properly before the court.
It was. It was. So let me move to some of the other issues that were addressed. The Trianon case does not control. The reason why the Trianon case does not control, and now we are getting into the issues of duty, and I apologize, but I'm going to, yes.
Assuming, for the sake of argument, that the issue of duty is properly before this court.
Yes.
On what basis did the appellant owe an individual or special duty to the decedent?
Okay. The basis, well, first of all, I would point to the evangelical brethren test. Is the question act, omission, or decision essential to the realization or accomplishment of the policy as opposed to one which would not change the course or direction of the policy? This has nothing to do with policy. It's operational, number one.
Well, again, I hate to interrupt, but
yes.
The United Brethren case doesn't discuss whether there's a duty owed. I mean, this whole thing about...
Correct, and I'm answering, let me finish my answer with all due respect. So the real answer to Judge Lewis's question can be found on page 1048 of the Wallace v. Dean opinion. And what they do, they cite the Pollock case. And what they say is a special tort duty arises when law enforcement officers become directly involved, and they talk about the zone of risks subjecting people to danger. And here's the answer to the specific question that was raised. And this also answers the Trianon question, because the court specifically posits the special tort duty is an exception to the Trianon any category. Once an officer or once law enforcement becomes directly involved in a circumstance which places others in a zone of risk or subjects them to danger, Trianon doesn't lie. But I still haven't answered Judge Lewis's question, and here's the answer. Footnote 23 to the quote about otherwise subjecting them to danger says, for examples, and this is the Supreme Court in Wallace on page 1048, for examples of law enforcement activities creating a zone of risk that affects a determinate individual or group, and they cite about 10 different cases. For instance, City of Pinellas Park v. Brown. Officers conducting a high-speed chase of a man who ran a red light had a duty to reasonably safeguard surrounding motorists, the group. Or Brown v. Miami-Dade County. When conducting a sting operation in a hotel, the police had a duty to reasonably protect the safety of innocent bystanders.
But counsel, is there any record evidence in this case that the decedent had any contact with the 4 FHP troopers who were posted on I-75 at the time of the reopening of I-75?
And in all honesty, there is not. Just as there is no record, nor can there be a record, that the motorist who was injured or killed in City of Pinellas Park v. Brown when there was a high-speed chase that started 3 counties over, and a motorist eventually found themselves enmeshed in the chase and were injured, they had no contact. And in the Brown v. Miami-Dade County case, when conducting a sting operation in a hotel, the police had a duty to reasonably protect the safety of innocent bystanders.
Well, I'm wondering if there's a duty, how long does that last? The road was closed. It appeared to be safe and clear. Perhaps they should have monitored it better after it reopened. But it reopened 2 days later. If the smoke arose again and there was the inversion, are you going to be here saying there was a duty at that point? How long does that duty persist?
That's a really good question, and let me try and answer the question. One of the problems noted is that the FHP, after the 2008 horrible tragedy in Polk County, enacted a checklist of rules to follow, basically, in smoke fog incidents. And one of the rules, and I know this is a little convoluted, but I will answer your question. One of the rules said, check with the Florida Forest Service. Check when there's smoke and fire, check with the experts. Check with the Weather Service and check with the Forest Service. And let me just try and answer. I'm a sentence or two away, Your Honor. What happened in this case is the Florida Forest Service did what they were supposed to do at 8 o'clock the night before. They called FHP and they say, you know, early in the morning, we think that smoke is going to be really bad and you're going to have to consider closing the roadway. That warning from the Florida Forest Service was ignored by FHP, one of the acts of negligence. Furthermore, the National Weather Service, who FHP, according to their own operations manual, was supposed to check with, had a smoke warning until 9 o'clock the next morning. So we have a determinate time and we have a determinate place. The place was Paynes Prairie, 4 miles. They didn't put police cars down there on the road to warn people. The time was set by the National Weather Service. The warning is there until 9 o'clock. It was set by the Florida Forest Service, who specifically told them in the early morning hours, it's going to get worse. You need to be really careful. You may have to close the roadway. And after the tragedy, at the expense of numerous lives lost in Polk County in 2008, there were legislative hearings, there were rules passed, there were specific entries into the manual telling them what to do. And the time was set if only the officers had followed their rules and checked with the experts. So I'm not suggesting there's an indeterminate time here. What I am suggesting is what they should have done is followed their rules, checked with the Florida Forest Service, called them up. They would have said, yeah, in the early morning hours right before dawn, it's going to be bad. The Weather Service would have told them, and it's coincidental that the Polk County tragedy also happened in January during a special weather condition called an inversion. And I'm no great expert, but there's testimony that in an inversion, the smoke is held really close to the ground, and then it dissolves as soon as the sun rises. So if they checked with the National Weather Service, as they were supposed to, they would have seen that the conditions were prevalent or predicted right there, in the warning. There were numerous warnings that night by the National Weather Service. They had to stay on top of this. They had to follow their own rules. And their own rules said, check with these people. So that's my long-winded answer to your question, Your Honor. It was not an indeterminate time.
Back to the sovereign immunity analysis.
Yes, sir.
Why is Category 2 of the Supreme Court's opinion in Trianon Park not controlling on the facts of this case?
Category 2 is not controlling because the Supreme Court of Florida, in the Wallace opinion, specifically said Trianon is a rough guide, and the plaintiff must be given an opportunity to plead facts alleging that the government actor owed the alleged tort victim a special duty of care, i.e., to plead exceptions to the public duty doctrine. We have outlined the following disjunctive list of exceptions to the Trianon public duty doctrine, and one exception is a special tort duty which arises when law enforcement officers, it's the undertaker's doctrine, when they become directly involved in circumstances which place people within a zone of risk or otherwise subjecting them to danger. And I would also point out, in terms of the sovereign immunity question, which this court seems to be very, very concerned with from a jurisdictional point of view, from a sovereign immunity point of view, DOT v. Nielsen, Payne v. Broward County, and two first DCA cases, Wright v. Department of Agriculture and White v. Waldo, hold that the failure to warn of a known danger is, in our view, a negligent omission at the operational level of government and cannot reasonably be argued to be within the judgmental planning level sphere. Clearly, this type of failure may serve as the basis for an action against a governmental
How do you define
entity.
known danger in that context?
Excuse me?
How do you define known danger in that context applying to this case?
I define the known danger in this case in a number of ways. First, we have the known danger of great loss of life in 2008 in almost the same situation. Secondly, we have the warning of the Florida Forest Service that the dangers are going to increase in the early morning hours. Thirdly, we have the specific warnings of the sergeant on the scene saying, this is going to be really bad, don't do it, don't do it. The lieutenant arrives there. The sergeant has seen, let me say this, the sergeant had seen the earlier crashes. So there were earlier crashes caused by the smoke. Now, this court hasn't seen the videos and can't see the videos of from the police cars of just zero visibility. But the sergeant saw the zero visibility. You couldn't see anything. That was the known danger. And when the Florida Forest Service called up FHP, and it was ignored, when the FHP ignored the Weather Service, they issued essentially a known danger warning. That's what they did. They say, we predict heavy smoke warning for Alachua County. Cars were crashing all over the place on 441 and I-75 before the road was closed. That's why the road was closed. It was absolutely a known danger. And it was a known danger that resulted in the deaths of 11 people because bad decisions were made because they undertook a duty. They did it poorly. They didn't follow their own rules. And the jury should hear this case. The judge should be affirmed in her denial of summary judgment. Thank you.
Thank you, counsel.